everyone. Thank you for joining our commercial contracting webinar. My name is Catherine. I'll be your moderator today. As by way of introduction, I am the founder of Calico Law, which is a boutique law firm specializing in complex commercial transactions and data privacy. And I work very closely with Lehot and L2 Counsel as a commercial and privacy consultant. And today we have a really great lineup for you of speakers as well as discussion topics, which is commercial contracting considerations for startups. Now, a lot of times it's easy to view commercial agreements as an annoying transaction cost, which frequently or sometimes they can be. However, if you ask most people in the audience or anybody if they would be comfortable leaving an important strategic partnership or customer agreement to a handshake agreement, they probably wouldn't be comfortable with that. And so commemorating things in writing and having a written agreement is a practice that goes very far back in our society. And it's how we, as a society, commemorate commitments and hold people accountable. We need to have it in writing. So in that sense, commercial agreements can really be viewed as the vascular system of your business activities and operations. If you have bad commercial agreements, so this can be poorly drafted commercial agreements, agreements that are missing key terms, or conversely, agreements that are too long and have unnecessary terms, this can create a lot of friction within your business. Serious deficiencies in your commercial agreements can impact your business itself, leading you to take excess commercial risk in your contracts. This can result in negative impacts to your company's trajectory. It can devalue your intellectual property, and in some cases, it can even bankrupt the company. On the other hand, when your commercial agreements are well drafted and you have good commercial agreements, then like a healthy vascular system for the human body, it can support and supercharge your business processes and operations. You'll be able to close deals faster while protecting the company. And in the event that anything goes south or the engagement doesn't go as planned, you'll have definitive recourse set out in the terms of the contract. And so for many early stage companies and founders of early stage companies, there are resource constraints. So commercial contracting really is about how you can avoid bad contracts and spend your resources getting good contracts where it really matters. And I know that sounds easy, but anybody who's a founder or any person, operationally minded person, knows that in practice, it is not as simple. And so I have here today with me an eminently qualified panel with a deep bench of experience spanning legal, spanning business operations, as well as finance. And together we will take you through a discussion about how you can make commercial contracts work for your business. And now I'm going to allow the panelists to introduce themselves.
So the first question comes to a lot of entrepreneurs and founders, and even to an extent a finance person. We get asked a lot is, how much is the right legal budget should I think about, right? So my advice is set up a proper budget. Do not be so flimsy on that side, because at the end of the day, this is laying down the foundation and structure of your company and putting the right protection/barriers. So that is what I would advise to a number of founders at the onset of the company formation stage.
I couldn't agree more, Jenny. Bret, do you have anything to add on this?
No, I'll just tag on to the fact that that IP is usually the big issue, especially obviously for a tech company. And so Jenny mentioned CAI, which is confidentiality agreement and invention assignment, meaning who's going to own the intellectual property that's produced. Hugely important issue. And then, I always tell, so especially in Silicon Valley, most startups begin as a side project while you're working for somebody else, right? And so I always tell entrepreneurs, first thing you do is check your employment agreement with your current employer, because probably the IP that you're producing during work hours belongs to the employer. And so, don't make the rookie mistake of writing code on the company laptop for your new startup, because that probably technically then belongs to your employer. So again, for me, it begins with kind of thinking about these IP issues early on and making sure that you've got documents in place that make it really clear who owns the IP. A lot of times people will do their initial application development by hiring somebody on Fiverr or on Upwork, right? Again, make sure that the IP rights are clearly defined in that agreement. Otherwise, some random person on Fiverr is going to say that they own the intellectual property for your startup.
Yeah, definitely a pitfall to avoid. Those are all really great points. Thank you, everyone. I think another common question that comes up, and maybe this is more pertinent in the third-party commercial contracting arrangements, and I'm going to throw this one to you, Louis, is, we want to save money. Can we just copy another company's commercial agreement, terms of use, and just, co-opt it as our own? What are your thoughts on that?
Well, that's a great question, Catherine. And one of the theses behind our firm is that startups need legal counsel the most when they have the least amount of resources. That's at startup and at formation stage. And that's when you're putting everything together and where the mistakes can be the most severe. And so it really pays to work with somebody that is going to take your phone calls, that's going to, as Jenny points out, work within your budget in a predictable, repeatable, scalable fashion, which is a problem that we're trying to solve at L2 Counsel. Oftentimes people will think that they learned in Y Combinator or some other place that they can just copy somebody else's contract or somebody else's privacy policy and boom, put it on their website and they've checked the box and solved the problem. And while that might get you 10% of the way there, or 90% of the way there, if you don't consult with somebody who knows what they're doing, you might really cause harm to your business. And it doesn't take a whole lot of time or resources to engage with your trusted counsel who can say thumbs up or thumbs down, or can take a quick look at it and tailor it. And I think it's also an ongoing conversation, Catherine, as what you do at formation, which is just good enough. Remember, perfect is the enemy of the good. It often will need to evolve when you get to the next kind of milestone in your development. Jenny, what's your experience?
Yeah, I agree. How do I say, like, things coming in my mind, there's so many different things. Budget is really good exercise, right? It's a lot of times this is a new experience. And so like entrepreneurs, founders, they don't know where to draw the line. Like, is that 10,000 too much, too little? What should we think about? And copying over somebody's is a very dangerous exercise. Obviously, if you go to any website and a Combinator or whatnot, tons of safe, post-run evaluation, it seems like you can just lift it and use it. However, what attorneys spend the most time is learning about the client business, right? Everyone is slightly different. Their risk, filters are very different. The valves that you need to throttle up and down are all different, right? And how the data is intersected, they're all different. So you pay their time to really learn about your business and strategize. It's almost like a legal strategy, right? Even though it's a very cookie cutter, like a formation documents or safe documents or funding documents or really commercial SaaS licensing documents. That subtlety is what you pay for. So just copying, pasting is a very dangerous maneuver. And I can say that I have come across a number of CFOs playing pseudo attorneys as well. And that is not a good practice. I know enough to weigh in, and I can instruct people like Catherine, right? Like, I would like to structure this way so that we can mitigate, right? But actual red lines and actual legalese, I leave it up to professionals, attorneys.
Absolutely. Thank you, Jenny. And I really want to echo that. I think just as how you wouldn't copy another company's code and just use it for your product, you need to customize it. Similarly, for legal documents, you can't just take one and swap it out for one business for another. So really great points, everyone. Thank you so much. I do want to keep us moving because we have a lot of ground to cover. So the next topic here is on funding. And commercial agreements as it relates to funding. And our first question here is, we're taking a little bit of a thinking outside the box approach. So when you think about non-traditional funding, so not just raising venture capital funds, how can commercial contracts facilitate the inflow of non-traditional funding? Jenny, we'll go to you first.
Yeah, can you define non-traditional funding first for everyone?
Yeah, so non-traditional funding is potentially, a revenue share in a contract. It's a way of getting money in the door that's not, venture capital financing, convertible debt financing, things that we see more commonly. And ideally, it's actual money that you're getting paid, not attached to anything.
Yeah. So these days, there's a lot of liquidity-driven funding events, right? So it's not novel. Those things existed, and these days people package it better. That's how I see it. So RevShare, for instance, you are a US, I'd say B2B SaaS company, and you have a very predictable revenue streams and collections, right? And why don't you leverage that? Because it is an asset. In US GAAP sense, asset is defined as a future economic benefit, right? So if you're a SaaS company and if you have a future streams of revenue, that becomes your asset, and therefore you hang it on the balance sheet, right? I explained this to people. So let's say you have a 120,000 contract for 1 year. You recognize one piece and peanut spread, just spread it out. The remainder is your asset. Therefore, banks and other financial institutions look at you. Why don't you leverage that instead of going outside, raise equity and dilute your ownership, or raise debt and pay tons of money just to interest payments, right? So that makes sense. And there are many, banks and financial institutions sprouting, and few of them are doing really well as a company. So if you look at that, and the way that you need to think about is still the structures and the terms of a traditional financing apply, such as interest, duration, the term structure, how you make the cash flow work, right? And debt covenants. They don't say debt, but it is essentially debt, right? You're leveraging your future, you're mortgaging your future revenue streams, right? So those concepts agree, and economically it needs to make sense. A good deal in all cases, it benefits both, not just a one side lopsided, right? So the timing of cash flow, all those things need to be taken into consideration.
Absolutely. Louis, do you have anything to add to that from what you've seen in your experiences?
Well, yeah, I think it's a really good question. I'm going to take it in stages. At the very earliest stage, when you're trying to raise capital, I find that a lot of startups need to demonstrate some proof points that there is a product market fit. So they've identified a problem, they've created a solution, and now they want to raise some sort of capital. And so the first thing I tell them is you're having these discussions with potential customers, potential channel partners. Get me an LOI, some letter of intent, very softly worded, that demonstrates that you have interest from a customer, that there is an ongoing conversation. And it's maybe too early for that to be recognizing revenue, but I find that that's one way to really demonstrate to an investor, whether it's an angel, a friend, a family member, or if you're really lucky, a venture firm. Next, I find that you might get to a point where one of these customers is interested in adopting your product and being what we call a POC, a proof of concept. And usually you're not getting revenue for that, but it implies that both parties are going to commit some resources to the relationship and see if it works, prove the concept. And that's even more compelling, obviously, than just an LOI. So obviously, as many of those as you can collect as you can, are great. And having somebody like Catherine review those in advance or develop those documents before you sign them is really important, so that it's clear who owns whatever intellectual property is created through that proof of concept mechanism. And then finally, when you've gotten through that part of your product development, and you're ready to what we call go into commercial shipment or ship your product, or in fact get revenue for it, then you really need to spend some time brainstorming all the different ways that value is being created, all the different ways that IP is being created, all the different ways that data is being created, who owns what, who's responsible for what, and making sure that you have some sort of agreement that sets this out. And I really enjoy working with you, Catherine, because you're so good at taking clients through this process and helping them come up with an agreement that works. And those agreements are really what are most compelling at funding. And obviously, if you don't have agreements, and you have sophisticated investors come in, they're going to look at these pieces of paper and have all these questions. And certainly you wouldn't want to scare somebody away by having given a royalty-free permanent license to your IP for the rest of all time to a customer inadvertently. So those are my 2 cents on that topic. And I know, Bret, you work with a lot of startups trying to get to monetization and of course to raise capital to get to monetization, and you've got great experience here as well. I'd love to hear your perspective.
Yeah, again, I'll just mostly kind of tag on to what you guys have said. And here's the big thing that I think every entrepreneur needs to keep in mind, is that the due diligence gets more and more onerous as you go along. So in other words, 2 years from now, when you raise your first venture round from Sand Hill Road, you're going to be so excited that you've got a term sheet from a venture firm on Sand Hill Road. And then you enter the diligence period, and they're going to want to see a copy of every single contract you've ever signed, literally. You want to be able to sail through that process smoothly. And you want to have contracts that are nice and tidy, and IP rights are clearly articulated. And as Louis said, an awful lot of deals get killed at that point. An awful lot of deals get killed because something comes out in due diligence. In due diligence, you mentioned that your Uncle Bob gave you $100 grand to get going. And then the VC is going to say, okay, so how was that documented? You say, I don't know, Uncle Bob just gave me a check for $100 grand. So, okay, well, is it a loan? Is it, is his expectation equity? And, and then it finds out that Uncle Bob thinks he owns half the company. So the point is, it's just so important for so many reasons so first of all, running a company is all about mitigating risk, right? That's really what a CEO does all day long, is look for opportunities for growth and look for opportunities to mitigate risk. And having clean and tidy contracts is a huge part of mitigating risk, especially if you're expecting to raise future funding rounds where you'll be subject to very, very deep due diligence. That's my experience.
Absolutely, Bret. I could not agree with you more on the risk mitigation front. As lawyers, Louis and I, that is always what we're going for our clients, is to mitigate risk but still preserve opportunities for growth. Thank you, all of you, for really insightful perspectives there on funding and commercial contracts. We're now going to move into the meatier portion of our webinar, which is scaling. And I think this is where a lot of companies and potentially even a lot of members of our audience today find themselves in, is at this stage. And it's a very exciting stage, but also a very challenging stage in a company's life cycle. So first question, you guys all have really great, really deep experience in various areas of expertise. What are some tips or best practices on how to scale your organization from a few strategic contracts to many contracts at volume? And Bret, I know you are an operator and very competent at that, so I'm going to start with you.
Sure. So first of all, let me say that I think that one of the great things about being an entrepreneur in 2021 is the number of tools that are available to you. And as you guys know, as attorneys, cap tables used to be one of those things that were kind of difficult to manage, and the law firm always had the most recent cap table, and then there was confusion. And these days there are a couple of terrific online platforms for managing your cap table. And so that's kind of the first thing I would say is, take advantage of the tools that are available today. And that's part of how you, as a small organization, are able to run with kind of efficiency that, once required a 30-person operation, you can now run with a 5-person operation by making use of some of these tools. I know there's also some contracting platforms out there. I don't know much about them. So I'll defer to the attorneys to talk a little bit more perhaps about those.
Yeah.
Hey, thanks, Bret. And one of the problems that we're trying to solve for at L2 Counsel is that we find companies come to us and they have 3 big problems. One is, do they have the right legal structure? Do they have the right agreements in place to be monetizing, getting to funding and getting to scaling? The second thing is obviously fundraising. And the third thing is, once they've raised funds and they are monetizing, is what sort of finance function do they have? And we work closely with Jenny and her firm, Evergreen Finance, to support many of our clients because she's built such a great platform for them. But really, I think at scaling mode, you're really trying to be operational, and you're trying to make sure that there is a process in place where you're generating leads at the top of the funnel and you're bringing those forward. And at some point, you're putting in front of the customer an agreement, and then before that agreement gets signed, you're making sure that it's looked at by your internal or external counsel if it's not on exactly the approved words, that the SOW has been looked at by your CEO and maybe your CFO, and that there's a signing authority process so that somebody down the organization who may not be aware of all of the legal and financial consequences of the agreement don't kind of fall off the rails by closing a contract that doesn't work. Finally, Catherine, I'll make one more note, is that as you and I know, when we're working with a lot of startups who are contracting with large companies and the leverage is really off. In other words, you're not going to go to, and I don't want to pick on a big company, so I won't name any names, but if you're going to contract with Goober, for example, which is a fictitious company, you're not going to try and impose on them your form of contract when they already have one. Really, it's a question of, okay, how can we understand what the Goober form of contract says, and how can we live with that and implement it so that we can monetize with that large customer quickly, which might be a key to our success. So some thoughts there. Finally, I'm going to close on some of the fantastic contracting platforms that are out there. I think many startups know about Salesforce and how to manage your customer relationship there, but there are a lot of plug-in apps on top of Salesforce or applications that have integrations with Salesforce, or some that don't, but that help you manage the contracting process. And we had a webinar a couple of months ago, and I want to drop a little plug for my friend Olga Mack at Parlay Pro, who's built together with her co-founder something really, really awesome to help manage the paper flow when you have an enterprise SaaS software business, which is contract intensive.
Yeah.
I can add to that. Scaling is the most fun part of running a company, right? Now you have the basic foundations and you get so many inbound inquiries from the customers, and you see the beginning of the S-curve or hockey stick growth. So from my experience, it is really fun and challenging at the same time. So how other companies deal with this is how they manage the chaos, literally, which is, I've seen this works really well. So I'll propose something that is one of the best practices. The first strategy is set up the cornerstone contract, right? So let's say you have a B2B SaaS is your business, then make it a template. This is our standard. And these are the things based on the most frequently negotiated terms. And when you set the terms, especially when Louis talked about being off, right? You're dealing with the Fortune 50 companies, Fortune 100 companies, where you are Series A company or Series B company. So the balance is a little off, but you, going into the contract negotiation, you set the bar at 1 to 10, 10 being most favorable to you, you will set it as a 7 or 8 and willing to go down 5 or 6, depending on the contract, importance of the contract or the size of the contract, right? So with that mindset, with the standard terms that you are happy to live with and protect the company to an extent, and that's how you negotiate. I mean, nitty-gritties of the terms, we can talk about it all day long. So that's what worked well. Individually, you know, the contracts work well. The second one is you start getting partnership contract, resellers, VARs, and all of the above. And you know, one single platform becomes an embedded version of something else. It gets a little more complicated. Also proactively set the standard contract terms so that when your salespeople come, here it is, it's ready, right? And sometimes people create depository of standard contracts in Salesforce. And it's easier for salespeople to go grab it, right? The second part is along with the main commercial contract are utilized, and there's compliance and privacy documents that go along with the main contracts. Also work with attorneys to make the main contract the cornerstone ones, right? It makes the process so much easier. Then you deal with it, then you use quote unquote your paper, and you know your salespeople are so, you know, accustomed to it, so much easier, and deal closure time gets shortened and shortened as you go, right? And we can talk about stock options and all the other contracts, it's like the same context. Just start with a very basic cornerstone templates, then you scale up and deviate, create derivatives of those contracts.
I think Jenny makes a super great point, which is that growing a company is all about accelerating the sales cycle, right? That it's all about trying to reduce the amount of time between making an initial contact with a prospective customer and having that turn into a signed deal that is generating revenue, right? That if that takes 6 months, that's a difficult way to grow a company's revenue. So you want to try to compress those sales cycles as much as you can. And having the customer contracts on some sort of a path that allows for that kind of a quick sell cycle, I think is really, really key. So guys, I'm sorry to do this, but I now need to board my plane. So I'm going to drop off this call. But Jenny and Louie and Catherine, thanks so much for inviting me to participate. This has been awesome. And the rest of you, I'm easy to find on LinkedIn. I'm just Bret Waters. So I'd love to hear from you. Thanks, you guys.
Thank you, Bret.
Thanks, Bret.
I agree with everything that's said, Bret, as well as Jenny and Louie. And the only thing I'll add to that is when you are scaling, there are more and more functional groups. And I think Jenny touched on this a little bit, involved in the process. What might have started with, you know, just the founders negotiating your first enterprise customer agreement turns into the sales team, and then the customer success team, and then finance to approve the payment terms. Many functional groups can start to get involved as the company scales and as you start selling at scale. So I would also emphasize that standardization that Jenny mentioned becomes very important in order to coordinate across all of these functional groups as well. Now, that being said, our next, and I think we covered this a little bit, Jenny, but I do want to come back to this because I think it's something that our audience would be interested in. Have there been any, you know, in your seasoned experience as a CFO, have there been any particular internal company policies that have been helpful in governing commercial contracting at scale within the organization?
Yeah, so it goes back to setting the bar, right? What is acceptable risk to you and how you calculate the risk and take it. It's super tempting when you close a quarter, you know there is a board meeting and we are not meeting the revenue target or booking target. Very, very tempting to cave in, sign up for somewhat higher risk, right? Then the discipline in the organization is what is our permissible risk and what can we tolerate and what is the benefit. So like assessing the trade-off is a constant juggle. There's no written rule, especially startup companies. Things are fairly fluid, and it should be because you are growing and you are seeking the right place in the universe, in your space, right? And it's a constant juggle. So I have seen some companies very, to an extent, rigid in my mind. It's certain terms, they have to go to the board, right? And, Catherine, you probably know this, limitation of liability. What is unlimited? We can sign up to unlimited. What is cap at X multiples of the revenue, X multiples of the contract size, right? They will put loose rules around that. But when it comes to unlimited liability, we shall seek board approval. But that creates a lot of friction because a lot of start companies, they need to shorten the cycle of the deal closure. And you don't have time to chasing the board, the signatures and all that, right? So something to think about and something to weigh your benefits and trade-offs there. Some companies, it's a CEO's discretion. Some companies will seek literally signatures, at least email saying not, right? CFO says yes, CEO says yes. And sometimes depending on very complicated CTO, like technical stuff, then CTO needs to weigh in, right? A lot of times these days, the CCPA, GDPR, like data, masking issues, CTOs also need to weigh in, or sometimes CSOs weigh in, right? So I have seen those practices. So it's a wide range, some all the way to board. Some will say that is not possible in our company. Our culture is not like that. And board actually, sometimes they don't want it, right? They don't want to be chased by portfolio companies, officers about sign the terms that they were about to sign. So whatever works best for you, and you just need to adapt and really, really think about what is the acceptable, permissible risk to you that you can swallow, you're palatable to you.
Yeah, I totally agree with you. That's a key question to be asking yourself at this stage. What is my risk appetite? What amount of business risk can I and can my organization accept in these commercial agreements? And then, as Jenny said, calibrating your escalation approvals and your internal communications around that level of acceptable risk. Louis, I'd love to get your perspective here on how, as companies are scaling, as functional groups are growing, and even the situation where Jenny talked about, people are chasing various stakeholders within the organization. How can external counsel be helpful or be leveraged in a manner that's helpful during this time?
I think that's a great point. At first, I think for all the entrepreneurs who are out there, I really recommend that you work with a group of lawyers that you like and that are responsive to you and have some domain expertise in what you're asking them about. Because getting quick answers to your questions is going to be what moves things along. And if you're working with a firm that takes a week to get back to you and answers your one-line question with a 5-page memo and sends you a $5,000 bill, that's not going to work. By the same token, if it's a lawyer that you're asking a privacy question to and they don't know privacy law, that's me. I do not know privacy law. That's why I practice with Catherine. So they need to have colleagues that they work with that know what they're talking about and don't give advice that's out of their lane, if you will. Finally, you want to be working with a counsel who's also a business person. And Catherine, that's one of the great things I like about you is you boil a lot of complexity down into just quick, actionable questions that are like a decision tree. Well, if it's this, then here are the choices. We go there, and here are the consequences. And, we as lawyers need to be flexible because we're not the ones making the decisions. We're the ones who are telling you the consequences of your decisions and helping you make the right ones for you. But you ultimately, as the entrepreneur, the client, are the folks that need to make the call, and you should work with people that enable you to make the call that you want to make. So getting to yes, not working with people that are just Dr. No. So those are my thoughts on the point. I guess having just a workflow because there are going to be some processes that don't need counsel. So a contracts manager, for example, a non-lawyer is perfectly good and a great solution for companies that are processing contracts in volume and where terms necessarily that are legal are not being negotiated, that are non-legal are not being negotiated. And so having kind of a workflow that's efficient and quick and moves things along.
Absolutely. And I love how you affirmed there the trend that we're seeing here, which is process and standardization, and really thinking about how can we, make sure that the right people within the organization are on the right matters, becomes very important. I think Louis and Jen, you both did a great job of really illustrating the importance and the impact of that can make. So I would another angle at this that I think would be great to cover, just from a backward or hindsight perspective, is how can you save yourself from expensive mistakes regarding your commercial contracts? Like we've talked about, what you should do, some best practices. What are some mistakes that you've seen, or things that probably could have been done better that you would want to share with our audience today? Jenny, why don't we start with you?
Jenny's perfect. She couldn't do it.
Yeah, I have seen.
Doesn't have to be yours. It could be someone else you observed.
It's hard to quantify expensive, right? Because everyone's situation is different. So it can be expensive as in equity. I have seen, not commercial, but employment contract side that they didn't. So whoever started the process, right, back in CEO doesn't exist anymore. They didn't do a proper vetting process of their benchmarking, and they didn't ask around, right? The common mistake that I've seen, just so busy, just stay alive, stay afloat, and growing the business so busy that didn't have time to ask around. Now they're kicking themselves because they set the bar too high, right? They give out too much. The same thing with the customers, because the pricing, especially setting the pricing and just setting the unit economics, they just gave away too much, right? In hindsight, it's too much, but what are we going to do now? There is a recourse and series of actions you can take. Of course, you seek the counsel of the attorney and the professionals like CFOs and whatnot. Then there is a way that if you have a healthy relationship with the customers and customers are very happy with you, they're willing to sit down with you and renegotiate the terms. But the precursor is, the people are happy and they're willing to renegotiate because there's a benefit for both sides, right? I have seen the pricing conversation happening that way, equity conversation with officers happening that way, right? So having a very productive dialogue and make sure the terms are something that both parties can live with, then that there's definitely a recourse to course correct.
Absolutely. Louis, what are your thoughts? I know you have, decades of experience. What have you seen that we would want to encourage?
I'm not that old, Catherine. We're going to leave ageism out of this. But seriously, where this is going to come and bite us when we have a bad commercial agreement is when we try and collect and the customer is in trouble, when we're at a funding event and our investor is looking at our contract and thinking we've given away our IP or we've given away revenue streams, or three, and most importantly, is when you go to exit. When you're looking at selling the company, and if you're selling to a big tech buyer, you can be darn sure they're going to have a lawyer that's going to find your contract and find something wrong with it. And it happened to me a few years ago. And I'm going to genericize this so I don't share anybody's confidential information, where a buyer looked at a seller's contract and there was a way to read it that they had given away all of their intellectual property and data to the customer. Now, the customer was in no position to use this intellectual property or data, and this customer was never going to be in any position to be interested in monetizing it. But it raised this theoretical question of whether the seller could actually be selling exclusive rights or licenses to its IP without the consent of this other first large anchor customer that had the bad contract. And a valuation adjustment was made. And an insurance policy was purchased, and it delayed things by months. Now, thankfully, the transaction still took place. But these are things that can adjust for value significantly. I had another situation a few years ago where a business was interacting with customers using text messages in violation of the Communications Privacy Act, or TCPA. And as we learned on the TV show Silicon Valley on HBO or Showtime or whatever it was, if you send somebody a text without complying with the TCPA, you have a statutory fine. The statute just tells you it's $8, or I can't remember how many dollars it is per violation, and it's a statutory. So that makes you a prime victim for a class action lawsuit, and boom, there was a valuation adjustment made for the liability, and then a plan of action was put into place to go fix the terms of service so that going forward we were making these text messages in compliance with TCPA, and that the value was adjusted downwards. So getting it right, is important, and getting it wrong has consequences. And working with a team that is well informed, is looking and being thoughtful, thinking ahead about where the product is going, will serve you well. So Catherine, for me, that's you.
Yeah, right back at you, Louis. No, absolutely. A lot of times, just as Louis mentioned with the example of TCPA, the compliance is really a very, I don't want to say minimal, but a lot, if you're thinking about like consents and things like that, it might take some time to put that together. It pales in comparison to the consequences of not having that and then having to clean it up, at a later stage. So I absolutely agree with you there, Louis. And Jenny, thank you so much for your perspective as well. It's very helpful. All right, well, I do want to leave some time for Q&A because I think in case anybody does have questions. So Louis, I'll pass it back to you for the Q&A.
Thank you. Well, we've seen some Q&A through the course of the panel discussion this morning, and I've been trying to answer them live, and hopefully you can all see them on my screen. And those are all exhausted. But those of you in the audience, you are welcome to type in any question using the Q&A feature here in Zoom or the chat. I'm looking at both, and so we're open there, and a couple of minutes left. Catherine and Jenny, any kind of parting words of advice for companies that are looking to build out their commercial contracting function, either at the funding, formation, or scaling stage?
Yeah, so one thing that I point out is more philosophically, right? Because when you run a company or part of the team, founding team to run the company, time is of essence, and you don't have much. Everyone is 24 hours a day, right? So like, where should I focus on? And how am I going to absorb all this information, right? Let's say you're a technical founder. This finance concept, legal concept, it's a lot to take in. So it's very important for you to pick the right partner, right? Legal strategy partner, right? Finance strategy partner. Those people will not feed you just textbook answers. And they will not tell you because of XYZ accounting rules or XYZ a legal concept, this will not work. The right partners will find a solution with you. They will talk about you, they will talk about the risk, the upside, downside, the trade-offs, and they will find a solution for you. Literally, some founders would say, just get me out of this, give me a couple of options. It's not like that. Just having a conversation, know your risk, and coming to the resolution. And the right partners will explain things to you, not just feeding you textbook answers. It's really, really important to find the right partner that I can emphasize. The second one is more open-minded, right? Without learning, there's no growth, right? So we have to learn, and these are not really difficult concepts to grasp. You're running a company, that's the most difficult part of it. And just finding those partners help you is really, really good opportunity. Just one minor thing, along with the compliance we talked about, legal contract terms, commercial terms, some privacy issues and compliance. One thing that I have seen quite a lot, and even early stage, they come back and haunt you and bite you, get a massive haircut in valuation, in addition to what Louis mentioned, is actually tax, right? Sales tax or just accrued liability over the years. Those skeletons pile up and really bring the house down. So I have seen this so many times. Something to keep in mind, the tax side of the house that we didn't discuss here.
Well said, Jenny. Well said. And what Jenny is referring to is the fact that when you recognize revenue in certain jurisdictions, some taxes may apply. And generally, we don't think that we owe tax in a place, and sometimes we do. And the first place where I see companies running into a sales tax issue is they put an employee or some function in a different state. And then that state will view your company as having a permanent establishment in that state, and or performing some portion of the revenue that's being generated by your company in that state. And so they're going to want to impose sales tax on some or all of the revenue that you're collecting. And that can be a complicated analysis. Together with Jenny, we recommend a lot of different technology-enabled solutions where we can to help companies make sure that they can demonstrate their compliance with sales tax rules. And obviously, where does this come up? It comes up if you get hit with an audit. 2, if one of your employees or consultants rats you out. 3, when an investor, or most often when a buyer's counsel comes in, or obviously auditors come in and look at the quality of your earnings, and they'll hit you hard on your valuation if you haven't done it right. So well said, Jenny, to bring in the tax function in contracting, because that's a big deal. And we didn't touch on the accounting as well. There are a lot of other software packages that will help you account properly for your revenue. As if your revenue is, if you're taking in a 3-year license fee on day 1, for example, under generally accepted accounting principles or GAAP, you may not be able to take all of that revenue in year 1. In fact, you most certainly can't. So we call that the receipt of cash bookings, and you can only recognize as revenue that amount of dollars that corresponds to the delivery during that year. And then you've got to put on your balance sheet a debit for the deferred revenue that you're holding, for the services that you have to provide in years 2 and 3, and then you recognize those in years 2 and 3. So all of this stuff matters, folks, and people like Jenny are fantastic at making sure you have financial controls and operational controls in place to capture these points, and people like Catherine to put in place the right contracts from the get-go to monetize as best you can. And Catherine, I think you did a terrific job of setting out the problem at the outset. I apparently hit the record button too late to capture that, so I may ask you to re-record it after this. But we will be posting a recording of the webinar on our YouTube channels and sharing a link to that by email to all the participants. And if you like it, share it. And if you like Catherine or Jenny, please reach out to them directly. They're fantastic advisors, very busy, but well worth connecting with. And finally, I wanted to thank Bret Waters, and I wanted to drop a plug for his really great accelerator, which is called Fourthly, which is designed to help businesses that are focused on what's happening in the 4th industrial revolution, which is changing the way we live, work, and play together. So thank you, Catherine, and I'm going to wish everybody a great day.
Thank you, everyone.
Thanks, everyone.
Bye-bye.
Bye.